Deputy Adams, without interruption, please. Thank you.
I'm just wondering, Taoiseach, before I answer the question, have you any explanation for the absence of the Labour Party from the chamber?
Sorry, this is Leader's questions, Deputy, please.
I'm looking for information. Yesterday, Taoiseach, when I asked you when did Minister Noonan inform you about his department's deep concerns over the sale of Ceisteanna and the other IBRC deals. And you didn't answer the question directly, but you did give the impression that the Minister did not brief you on these issues. So I'm just wondering, how could that be so when this involved hundreds of millions of euros of taxpayers' money, and when officials in the Department of Finance raised repeated and very serious concerns with the Minister, and when they sought an independent review? And then in 2013, the Minister was winding up IBRC sooner than was expected. Now, clearly this was a big issue. Were you not briefed on this? The Minister knew it had cost hundreds of millions of taxpayers' money and hundreds of millions in gains for insiders. So what did he tell you, Taoiseach? We know that in the Dáil here on the 6th of February, speaking on the Irish Bank Resolution Bill, Mr Noonan said, and I quote, "I wish to acknowledge with much appreciation the significant efforts the directors and staff of the IBRC have made to the stabilisation and maintenance of value in the IBRC." Now, this statement is totally at odds with the deep concerns within his own department. So how does this statement square with the facts we now know regarding the concerns expressed within the Department of Finance? Taoiseach, the Government is supposed to protect the interests of the taxpayers. Yet you said to me yesterday in reply that Minister Noonan did not deal with each of the 30 or so transactions of over €100 million, which are now part of your review. Now, if this is so, is it acceptable to you, given that the Department of Finance officials have expressed such serious concerns regarding these transactions?
Thank you.
Even aside any other interpretation, does this not show gross incompetence by your government if what you're telling us is true?
Thank you.
On the contrary, as I've said to you, the framework structure set up by the previous government meant that there was no connection or no interference from or no questioning from the Department of Finance in respect of these major transactions, nor was it compulsory that the Minister for Finance of the day would be informed. And that was the situation that applied when the sale of the company in question happened. Minister Noonan, when he had the opportunity, changed that structure to make it mandatory that he would be informed of major financial transactions by IBRC. The documentation that was released under the Freedom of Information to the journalists who requested it was posted on the Department of Finance website, and that's a record, if you like, of the issues that were of concern to the Minister and his department at the time, and the actions that were taken to ensure that the best interests of the taxpayer were protected. And the documents confirm that the chairman of IBRC provided the Minister for Finance and the senior officials that he appointed with strong assurances that the transaction involving Ceisteanna, including those aspects of the transaction with which the department officials had concerns, had been thoroughly assessed by the IBRC board, which was confirmed by the chairman, and that the board of IBRC were satisfied that the transaction was managed in the best possible manner to achieve the best result for the state. Now, it should be noted that the IBRC had a fiduciary responsibility to the bank's shareholders, and in light of that responsibility, which was a legal responsibility, the chairman and the board would have considered and provided such assurances following very careful consideration indeed. But in light of the assurances that the Minister for Finance received from the chairman that this transaction had been properly considered by the IBRC board, assurances which the Minister accepted, the Minister and his officials took steps in line with the improved relationship framework to make sure that the department's role of challenging the board and challenging the executives of IBRC was in the best interests of the taxpayer, and that was strengthened by the actions that the Minister for Finance took. So clearly, as I said, the Minister for Finance kept the government informed of the progress that was being made in respect of the negotiations about the famous promissory notes, which you raised on many occasions here, which, because of that legacy, required that the government would have to raise €3.1 billion every March to pay interest that was due. And obviously that matter was brought to a conclusion following those negotiations. So all of those matters will be part of the documentation now sent in by the Special Liquidator to the Minister, with the independence of a High Court judge to adjudicate on any perception of conflict of interest. And as I say, the Dáil, the Public Accounts Committee and the other Oireachtas committees appropriate will consider that report where all the information is available. And if people have further concerns after that, considering that there has been an analysis by the IBRC board, by the Central Bank, now by the Special Liquidators of the direction of the Minister, and a further independent analysis, if the House wishes, by the gCeannairí, and I'm sure everybody has complete trust and faith in that independence.
Deputy Adams, 1 minute.
The problem, Concordia, is this, that I asked the Taoiseach a number of direct questions about his knowledge at different times as this scandal unravelled about it, and he never answered one question. Not one. You said, and I wrote it down, it was not compulsory for the Minister to be informed by his officials. But the Minister was informed by his officials. That's a matter of record. And for 3 years now, Taoiseach, the serious concerns at this Department of Finance were kept from the Dáil and from citizens. This was despite a large amount of questions from TDs here, including Pearse Doherty, who was stonewalled by Minister Noonan from 2012 onwards. So why in his answers to Pearse Doherty did the Minister not disclose what was going on? Why did he withhold information from the Dáil? Because the Dáil has essentially, and you did it again today, has essentially been misled on this issue, and in fact there's a cover-up of the facts. It has all begun to fall to pieces.
You better be very careful about accusations now.
I am being very careful, Concordia. I'm here to keep the government to account, and I do so within the rules. So the strategy began to fall apart when there were freedom of information replies to Teachta Catherine Murphy. The Minister received a recommendation from his officials to have an independent review of some of these deals. He refused to do it. So do you agree that the Dáil has been misled on this IBRC scandal? That's what the record looks like. And the opaque answers that you gave today, the very simple, straightforward questions, is part of that tradition.
Thank you.
On the issue of the review, and I stayed away from asking you about the review, because I didn't want you to get caught up in the gobbledygook that you usually spout. But why are asset acquisitions by NAMA from the IBRC explicitly excluded from the review that you have set up? And how do you square this with your much vaunted commitment to openness, to transparency, and a new way of doing politics?
Thank you. Taoiseach.
I said to you already, Deputy Adams, the relationship framework which was set in place before Minister Noonan's time did not require that the Minister for Finance would be informed in a mandatory fashion of serious financial transactions of that order. And as I say, when the Minister had the opportunity, he both changed the framework and appointed a senior civil servant. And the evidence from the Freedom of Information documentation shows the level of concern and action taken by the Minister for Finance in this case. Now, you continuously talk about cover-ups and a lot of other things. What I'm saying to you, Deputy Adams, is that the framework structure set in place when SiteServe was dealt with did not require mandatory reporting to the Minister for Finance. It does now. The review now being ordered by the Minister from the Special Liquidator goes back to 2009, right up to up to 2013 includes all of those cases. I understand that there are 30 or possibly more of the order of over 10 million. All of that documentation is now being collated and compiled and will be presented in report to the Minister for Finance by the end of August. And as I said yesterday, in the event of any perception of a conflict of interest in that review, he appointed a High Court judge to adjudicate on those matters. So the issue covered here then means that all of these transactions beyond SiteServe are covered in that period. As I say, this has been examined by the IBRC board, which has recommended very strongly that it did its job. We didn't take any action. Now the subject of this review, and as I say, the government have no difficulty, if it's deemed appropriate, that a further independent investigation would be carried out by, for instance, the office of the CNAG. We can't direct him because it's an independent office. The government have no difficulty in changing the legislation to accommodate that. So that all of these issues can be put on the table in respect of the taxpayer being defended, accountability for transactions, accountability for commercially sound decisions being made, and all of that is included in this.